So today we've taken the time to have a conversation with Andrea. Andrea specialises in family law, and we are dealing with wedding season in South Africa. And leading up to wedding season, I have a lot of clients that are planning to get married or are engaged to get married. And one of the key questions that we get a lot of, especially in terms of completing paperwork, the offer to purchase, is actually marriage regimes and the implications of each sort of marriage regime, that the client should be looking at. And, it's not my area of expertise. So I thought having a series on this and speaking to one of the experts would be a really good starting point in terms of letting our clients know what the different options are and what the pros and cons of each are. So I thought, let's have the conversation.
Okay. Thank you, Tanya. So in South Africa, we have 3 matrimonial property regimes. You have your in-community of property, you have out-of-community of property with the accrual, and then out-of-community property without the accrual. In-community of property, generally the default position, if you don't conclude a contract, where each party separate estates, once they get married, would form part of a joint pot, and that pot is divided on dissolution of the marriage, either by death or divorce, equally between the parties if it's on a divorce. The main factors in terms of a marriage in community of property also to bear in mind is that the parties need each other's consent for any transactions that they're concluding, agreements, etc., credit agreements that they're going to get involved in, and also the liabilities. The liabilities of the estate or of a spouse becomes joint. So that's one of the major. If a spouse is sequestrated, one spouse is sequestrated, that means that the other spouse is implicated and affected by that, and the joint estate is sequestrated. So that's one of the main issues that
Just to add on to that, what I've heard is when you marry community of property, that you obviously both need to sign when you're selling a property, and obviously if we at the stage of purchasing a joint property through me. But let's say if the client 3 years down the line is now married and decides to purchase another property, that they wouldn't need their spouse to sign, only when they dispose of the asset would the other party need to sign. Is that correct? Or do they always need to sign all agreements all the time?
Yes, so all agreements, if you're married in community of property, each transaction needs to be dealt with jointly. So you cannot dispose of an asset without your spouse's consent. If you do that, it's going to be void and it will be set aside.
Okay.
They do need each other's consent. So that is one of the main, I suppose, downfalls, if you see it that way, depending on how you look at it. Yes, and then I think that basically covers your in-community of property marriages.
And not so popular anymore?
No, not really. I would say the most common is marriages out of community property with the accrual system. That's where you have a sharing of the assets during the marriage, or the value. We generally refer to it as the value. So what happens with that type of system is the parties have their separate estates prior to marriage. On marriage, they still have separate estates, but the difference is that you could almost see it as a growth. So almost looking at it as, okay, we had separate estates prior to marriage, and now we are married, and we would like to share in that growth, whatever we grow together. It's calculated, there is a formulation that is used if we are looking at the accrual. So the accrual only comes into play on a dissolution, either by death or by divorce. So your estates are still dealt with separately during the marriage. You do not need each other's consent for any transactions. You can purchase your own property, your spouse can purchase their own property, they do not need each other's consent. They can obviously purchase property together as well, but they'll still be co-owners in their separate estates. So with accrual, you have a calculation that is, will determine whatever that accrual of the parties are. And that is calculated based off of what your commencement value, if anything, is stated in your international contract, with a CPI escalation on that value. And this parties whose estate has a lesser growth will have a claim against the parties whose estate who has a larger growth. And that's the party who has a lesser growth will have a claim for half of the difference of the growth. So that is how it's calculated.
In terms of getting your contract registered, so for example, the clients now are looking to purchase a property and they would be getting married in January, let's say. When is the right time to prepare your antenuptial contract, and how does that process sort of go, or how does it work?
So an antenuptial contract should be concluded prior to marriage. It can be any time before marriage, as long as it's before the marriage. There's registration of it that is important after you've concluded the marriage. There's obviously certain time periods that need to be complied with, but that's as long as you have entered into an antenuptial contract prior to your marriage, it becomes binding on the marriage. So as long as there's a subsequent marriage, then an antenuptial contract will be enforced. In terms of the consequences of any transactions, as I said, because it's a separate estates, you still deal with your estates separately. It's only that growth and the value of any growth. It's not assets that are divided per se, it is a value. It's calculated on value, but again, it's only if it becomes applicable. Marriages out of community property without the accrual. Again, assets that you had prior to marriage remain each party's assets, and during the marriage, the difference with a system that has the accrual applicable is that there is no accrual sharing.
And you'd still need a contract for that.
You would need a contract for that, and the contract will specifically state that, and you would still go to, so you go to, the parties would need to consult with a notary public with regard to the antenuptial contract, which then gets registered in the deeds office, and it can only be done by a notary public. The parties would as I said, they wouldn't share in any assets, they wouldn't share in any, there'd be no accrual between them. So whatever they had prior to the marriage, whatever they had during the marriage, everything is separate. There has been a very interesting development in the law where prior to the 1st of November 1984, when it was in the Matrimonial Property Act came into effect, there used to be a redistribution of assets on divorce. And the system where you have the accrual without, out of community property without accrual, you do not have any sort of recourse. So generally, if you were, for example, a stay-at-home mother, and now you're getting divorced, unfortunately, you would have no recourse because you concluded a contract where whatever your assets you had prior to your marriage will remain your assets, but whatever growth, however substantial they may be, you wouldn't have any sort of claim. So if you didn't work, for example, you would be very, prejudiced. And so the court found that was unconstitutional, and have now changed the law in terms of if you would like to claim in terms of a Section 7(3) claim against your spouse on a dissolution of the marriage, you can, subject to obviously certain factors, so they look at any sort of contributions that you've made during the marriage, and those would then impact whether you would have a claim. And so now the court, it is a discretion, the court has discretion as to whether they'll award certain assets or percentage of assets to a spouse if they were married in terms of the out of community property without an accrual claim or out on an accrual basis.
So in terms of your expertise, in terms of, most people, both spouses work, both have their own careers, what would be your advice to maybe a young couple getting married? What would be your option as your preferred contract?
It's difficult to say because it's very personal. I think it also it depends on the obviously it has very financial implications. I would say in the past that if both parties were well established, let's just say it was a second marriage for both parties, or one of the parties maybe they had previously been married and now they were getting married a second time, they would probably opt for out of community without an accrual because you can have a very established businesswoman, a well-established businessman. They're both running their own entities and yes, and they don't really want any sort of commingling, and they're quite happy with that sort of situation, and it makes it clean and neat if they get divorced. That would probably be a good way to go. Now, because the law has changed, depending on, again, like I said, any contributions that a party may wish to rely on as, in terms of enforcing a claim against the other party, it changes the aspects of it. I think that probably the most fair system is, and most common system is getting married out of community property with the accrual, because you have your separate estates that are dealt with separately prior to your marriage, and whatever whatever that growth is during the marriage, which is a union, marriage is a union, I think that is a fair system. Because like I said, it is the party who has a lesser growth has a claim for half of the difference of that growth. Okay. So I think that is a fair system. I mean, if you look at a marriage in community of property, if your spouse perhaps has huge liabilities and you now are affected by those liabilities, I suppose one could argue that is unfair. Obviously you've chosen to marry that way, but I suppose it could go both ways. I mean, it is a marriage in community of property. I think that you're aware of the risks, or should be, and ultimately that's one of the reasons that, or let me say, why I'm saying risks is because if a party, for example, is sequestrated, like I said, your insolvent spouse, that estate, will affect your estate because it's obviously a joint estate, so it's dealt with jointly, and then you would be affected by default. And that's why I think it's so important for parties to consult with legal practitioners, especially with regard to concluding antenuptial contracts. Because on divorce, when the parties are going through a tough time and are considering a divorce, that is the first document that they're going to
request.
The attorney will request, and whatever decisions you make and what you decide to exclude in that contract, because there are certain exclusions that can be set out in the antenuptial contract, which can be applicable to the marriage. And I think that a lot of those things need to be discussed, and certain of the parties, we do find that when they attend their consultations, haven't necessarily had a discussion as to what matrimonial property regime they are going to apply to their marriage. Many of them only learn about the different regimes at the attorney's office, and I think it's very important that parties sit down and they discuss,
have an honest conversation.
Yes, because it has huge financial implications for both parties. And like I said, it affects how you enter into contracts and ultimately any dissolution of that marriage, and how the assets or liabilities are going to be dealt with.
And also for us, it's one of the required documents when we're busy completing an offer to purchase or we're signing a mandate. One of the FICA documents, we ask for a marriage contract. So it's very important that the clients do their due diligence prior to entering any, with any agreements, especially as a young couple that maybe hasn't got the life experience in terms of, marriages and the implications thereof. So another one of our occasional situations is where we have two parties that are obviously engaging with me to purchase a property. Let's use a sectional title as a perfect example. Let's say the gentleman is a young professional and his partner is maybe somebody in an industry that has maybe less stable income, so which is not really able to apply for a joint home loan. So what we find is that obviously they in agreement in purchasing this property, but the property can unfortunately be only registered in the one party's name as they are unmarried. From what I've heard, there can be a cohabitation agreement drawn up between the two parties, especially if one of the parties is going to be contributing towards levies or rates and taxes or maintenance of that property. I just wanted to find out from you, what is your thoughts on that?
Yes, I think that if the parties are going to have some sort of arrangement along those lines, then it would be very important to enter into some sort of an agreement which stipulates what the contributions are going to be, so that there is no ifs and buts about who has contributed what, and in the event that now they need to decide what needs to happen to this property and there is an argument as to who has contributed and in what respects. So I think that's very important. And yes, to seek legal advice with regard to that, to drawing up that type of contract, I think would be very important as well. If you get married out of community of property, and I think you had a question where most people would be advised, I think in the past, to get married without out of community of property, on the basis that without the accrual, on the basis that if, for example, one party's estate was sequestrated, that then there wouldn't be any sort of repercussions for the other spouse, and that's not the case. So if what happens is, on a sequestration, the solvent spouse's assets will actually be taken into custody, and you have to then, as the solvent spouse, you have to prove that those assets are your assets prior to marriage, or alternatively that you acquired those assets with your own funds. Otherwise, they can form part of any sort of insolvency. So that is quite important, quite pertinent, because I think that sometimes people are under the misconception that that's not going to be the case. That each party's assets, as long as it's my assets, or if it's my, if you are going through a hard time, or you are,
it affects you, doesn't it?
Yes, exactly.
Which isn't
it's the grey area. So,
and in order to wrap up, is there anything that you'd like to end off with?
I think that what we've learned over the years is that these decisions, and the decisions that couples need to make, ultimately, as they're deciding on getting married, what type of matrimonial property regime, I think they need to really consider it carefully. I think parties sometimes, unfortunately, rush these decisions. They do not think about them, or don't really apply their minds. And to be honest with you, I think that most couples are in a bubble, which they should be, and they don't really want to think about what would happen, if the marriage had to be dissolved. Because you're obviously not entering into a marriage, thinking about what is going to happen if we get divorced. But unfortunately, it is the reality, and it is a decision you're going to have to live with for the rest of your life. And so I think that you need to have real discussions, and you need to know what you're getting into. And I think that sometimes also parties don't necessarily know the implications, and they also don't know what the other spouse necessarily has. What are the assets and liabilities that you're dealing with in terms of both parties, and what if anything's going to form part of this pot, or how they're going to deal with whether it's going to be separate estates, or whether it's going to be a joint pot, or whether it's going to be a shared pot. But I think it's just a very, very, very important decision, and I think that both parties need to be upfront with each other, and preferably before they see an attorney, but at least or ultimately when they are consulting, to properly disclose, be upfront with each other, and make a decision that they both agree on, hopefully. And at least then there won't be any surprises. We do find that parties, when they come and consult, sometimes even question whether they've got an antenuptial contract. Has it been registered? Oh my goodness, now I need to go and search for it. It is something that you can easily obtain from the deeds office, because it does need to be registered. But we find that people don't even know how they're married. They don't know if they've got an accrual. They don't know, or if the accrual is applicable. They don't know if there's, if it's not applicable. And obviously, like we said, prior to the Freiling judgment, there would be huge implications for a party who doesn't have the accrual applicable. If they were, for example, like I said, a stay-at-home mother who then doesn't have any income and is now reliant on the husband, and would effectively be left out in the cold, so to speak, if there was unfortunately a divorce. And so I just think that it's important for both parties to really think about it, to really know what is the matrimonial property regime that they're going to enter into. So like I said, there's no surprises at the end, because those surprises have huge financial implications for your family, for your children, and
Rather safe than sorry.
yes.
Absolutely. So guys, there you have it. Basically the recap to our conversation with Andrea is always get professional advice before signing important documents, and it will affect the rest of your life. So make sure you get the right advice. Thanks, Anne.
Pleasure.